The first case to come before us this morning is Willie Jacobs et al. Versus Equity Trust Company et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, if you let me know, I'm keeping track of the clock and kind of help you out when you get close to or into that rebuttal time that you intend to reserve. I don't know that it's really all that applicable to this case, so please don't use the names of any victims or minors, as we do live stream and place this oral argument on our YouTube channel. We have read the briefs and we are ready to proceed when you are, counsel. Great.
Thank you, Your Honor. I would like to reserve, let's say, 3 minutes for rebuttal. Okay, may it please the court. My name is Tom Lucchese, and I represent the appellant, the appellants in this matter. The court is probably familiar with this case, having issued a ruling last December, on December 20th, on very similar, if not identical, issues involving claims of privilege that we have asserted over certain documents in the discovery process. In the prior case, which I'll refer to as Jacobs 1, the opinion was written by Judge Callahan. Judge Hensel, you were also concurring justice on that decision. And Judge Carr, you are new to this matter, but Judge Schaefer was also on the prior panel. That prior case dealt with 50 documents that were disputed as to whether they were privileged or not. In overruling the trial court's decision that all those documents needed to be produced and upholding our claim of privilege, this court recognized in Jacobs 1 that the appropriate standard for review is de novo. And as we pointed out in our brief, this requires an independent review of the documents that were reviewed by the trial court. And this court can do that and render its opinion without giving any deference to the trial court's decision. In the prior decision, in the prior ruling, the court ruled, as I said, and upheld our claims of privilege with respect to all of the documents. All of the documents, in its so holding, the court recognized that the privilege extends to all communications between corporation through its employees and its counsel that relate to the seeking or the rendering of legal advice. The court further ruled in deciding the prior case that the affidavit that we attached from an individual named Mike Dia was sufficient to describe the circumstances relating to the creation of the documents and to support our claim of privilege. In this case, we have submitted a very similar affidavit from Mr. Dia and from Mr. Desich as well that articulates and describes in detail the basis for our claim of privilege over the documents. Moreover, the court recognized previously that in these exchanges between the corporation and its counsel, that the predominant purpose of the communications was for the seeking or rendering of legal advice and not purely or predominantly for a business purpose. This case is eerily similar to the previous one in that we have, once again, from the Common Pleas Court in Lorain County, Judge Bedleski, we have a half-sheet entry in which the judge announces his decision requiring the production of certain documents, but does not show his work, does not show his rationale or his homework as to how he got to those decisions. So once again, this court, applying the de novo standard, will be required to review the documents one-on-one, go through them one at a time, to review them to see if our claim of privilege is supported. I guess the good news is, whereas the last case involved some 50 documents, this case involves only 18. So your review will be, your homework in this case will be a little less daunting of a task. So there's 18 documents that are in dispute. 17 of the documents deal with the attorney-client privilege, and one of the documents deals with a different privilege called the bank examiner or the bank examination privilege. I want to first talk about the attorney-client privilege documents, and this is all set forth in our brief and the binders that the court has received with the documents. But just focusing on the 17 documents that concern the attorney-client privilege, every single document in that group of 17 involves communications between an attorney, either inside or outside of the company, and the company employees about legal advice and legal issues surrounding the circumstances that are at issue in the documents. For example, and I'll just group these for you as we group them in our brief. At tabs A, B, H, K, and Z. That involves A and B each involve two separate documents that are at issue, and the H, K, and Z involve one document each. Those are all draft contracts or agreements, and the discussions there, just so you can get some names in play, we've attached some cover emails to show what the context of these underlying documents are. They're all discussions between the client, Equity Trust, personnel at Equity Trust, and lawyers at my firm, actually, at Baker and Hostetler, Matt Graben and Katie O'Connor. And you can see there's dialogue back and forth about contracts and agreements that the company is considering entering into. At tab D, it's the same thing. It's a draft letter of intent, a deal with a bank called Liberty Bank, where comments are being sought or responded to by one of our attorneys here at Baker Hostetler, an individual, again, it's Matt Graben. At tabs V and W, there are documents relating to clients' inquiries about SEC responses and how to deal with the SEC on certain matters. And the attorneys involved there are two individuals from Ulmer and Byrne. One is Bob Fine, and I'm forgetting the other individual's name, but tabs V and W, you'll see email addresses at Ulmer and Byrne, which was the business lawyers for our client at that time. Tab X involves a response to customer complaints. And again, it's Bob Fine that's communicating with the client from the law firm of Ulmer and Byrne. At tabs I and J, there are draft customer applications that are being commented on by an individual named Lisa Orr, O-R-R, and you'll see her comments on those drafts in bubbles. Lisa Orr was an in-house counsel at that time at Equity Trust. And then lastly, at tabs K, L, M, and N, these are draft responses to customer inquiries. It's an automated customer inquiry response document that details how automated email responses will be sent to customers and what the content will be. And there's some redactions on those documents that we did to protect the communications from an individual named Tim Coleman. Mr. Coleman was the general counsel of Equity Trust at that time. And in the very beginning of that section, there's an email that's produced to you as part of document KK that sets forth, it's from an administrative assistant saying, here's the attachments. They contain Tim Coleman's and another individual's comments. So those are all clearly privileged documents. They all involve lawyers talking to their clients or clients talking to their lawyers about legal concerns or issues. And the DIA affidavit will provide additional information about the circumstances of those documents, but quite clearly the predominant purpose of each document is to obtain legal advice. The plaintiff objects the appellee, not used to being the appellant. The appellee objects to these documents saying that they're for business concerns, but that's, as I've just gone through, is just flatly incorrect. They also complain that the DIA affidavit is a boilerplate document that doesn't give adequate basis for supporting the claim of privilege. Again, that is also incorrect, and I think this court has already addressed that and found the last affidavit we submitted to the trial court from Mr. DIA to be sufficient, and this follows the exact same form, provides the exact same level of detail. And then lastly, the appellees argue that we have somehow waived the privilege with respect to these documents by agreeing to produce some of the other documents that the trial court found were not privileged over our assertion to the contrary. I think that argument is really disingenuous at best. When we worked with the appellees to narrow the issues for this court, we specifically stated in our communications that we were not waiving the privilege as to the documents that remained in dispute. Moreover, I think this court should appreciate the fact that the parties sat down and spent a significant amount of time to try to reduce the issues we're bringing before you. Had we not done that, you'd be looking at, I think it's some 66 documents. But we did conclude that some of the documents were probably not privileged, and we agreed to produce them to the other side. So I want to turn now, that concludes the discussion on the attorney-client documents. There is one document at tab WW that is protected from discovery under the bank examiner privilege. This is an evidentiary privilege that exempts specific types of evidence from disclosure during litigation. It's been classified really as a federal common law evidentiary privilege, although it has been codified or put into rules and regulations in various places. The purpose of that privilege is to encourage frank and open communications between a regulator, such as the Federal Reserve, which is the issue here, and the entities that it regulates. The document that we are seeking to protect is a draft response to a Federal Reserve inquiry of Equity Trust. And we think it falls quite clearly within the scope of that privilege. That privilege is recognized in Ohio. We have cited to a Sixth Circuit opinion from 1995, In Re Bankers Trust Company at 61 F3rd, page 465. And that gives a pretty nice summary of the genesis and the purpose of the bank examiner privilege. I really feel that, that document falls within the scope of that privilege without any question. Moreover, I think the issue of whether it needs to be produced or whether the privilege issue can really be addressed is maybe premature at this point. As we point out in our brief, we don't hold that privilege. Equity trust parties do not hold that. That privilege belongs to the regulator. And it would have been appropriate for the regulator to have been joined in this proceeding or to have been approached by the appellees with a request for documentation.
And counsel, I wanted to let you know you've just now passed that 3-minute mark by a couple of seconds. So yes. You may continue or reserve as you wish.
Thank you, Judge. So I would just close by saying on the bank examiner privilege, that issue really can't be addressed by this court because the trial or the regulator has not been brought into the picture to assert the privilege on its behalf, and that would have been the appropriate process to have followed. So thank you for the time warning, and I probably have about 2 minutes left by my count, so I'll stop.
Yes.
Thank you, Judge.
Thank you. Counsel for the appellee.
Thank you, Your Honor. May it please the court, my name is Kevin Hulick, and I, along with my co-counsel, represent plaintiffs' appellees in this appeal. Like opposing counsel said, there are 18 documents in dispute in this case, 17 that focus on the attorney-client privilege and 1 that focus on the bank examination privilege. Based on the sheer number, I'm going to begin by focusing on the attorney-client privilege analysis. And just at the outset, you can see from the parties' briefs, there's not a huge disagreement between the parties here on what the legal standard is. It's more based on these particular documents and how they fall within that standard and how they should be evaluated. So throughout their brief and through the oral argument, opposing counsel makes a lot of reference to the first Jacobs opinion, which of course found that the documents in dispute there were not privileged, were privileged and therefore could be withheld. There's many differences between that first case and this case. Now, the biggest difference is in that first case, all the documents related to one specific issue, the custodial account agreement. Here we have documents that vary in scope. Another major difference is the evidence that was used in the first case to uphold the privilege. Now, quoting directly from the court's prior ruling in Jacobs 1, the reason why those documents were privileged were based on Almer and Byrne billing records, Mr. Diaz's affidavit, other emails deemed privileged by the trial court, and the amended privilege log. They found that the confluence of those different pieces of evidence meant that there was substantial proof of that the predominant purpose of the documents there was legal advice as opposed to a business purpose. In this case, we're missing one key piece of evidence in that, well, opposing counsel is correct that Mr. Diaz's affidavit is similar to the one that was in the first appeal. At the same time, though, we don't have the Almer and Byrne billing records. There are no billing records that can provide that additional context of whether the information was going towards legal advice. Because after all, as this court recognized in Jacobs 1, there must be substantial proof that the dominant intent of the communications is to obtain legal advice. And that's substantial proof. It's not a 50-50 analysis. Defendants have the burden here. They have to show on a substantial level that these documents are legal in nature as opposed to business in nature. In their reply, the first page of their reply, they point out businesses, after all, are in the business of doing business, to explain that Equity Trust is a business and they make many business decisions. That's true, but that statement in and of itself shows that what business is very broad. Now, information that's protected under the attorney-client privilege is supposed to be read narrowly, especially in cases like this where we're dealing with a large client like Equity Trust that, as they recognize, have myriad business interests. The whole point of the attorney-client privilege is to be read narrowly so that it focuses solely on legal advice and doesn't prevent the production of documents that do in fact have a predominant business purpose. And after all, we can all agree that documents can potentially have both a mixed purpose, but in order for the attorney-client privilege to apply, the predominant purpose must be legal. So moving into these specific documents that are referenced in this appeal, of the 17 documents that apply to the attorney-client privilege, there are draft custodial agreements, draft account applications related to a acquisition of another entity, Sterling Trust, a draft letter of intent with the bank, draft insurance deposit agreement, draft responses to SEC inquiries and subpoenas, draft responses to Better Business Bureau complaints, drafts that went to in-house counsel that include draft customer account applications and draft responses to customer inquiries. As we can see, this is not the same narrow issue that as was the case in Jacobs 1. Now, it's plaintiff's position that for all of these documents, the defendants have failed to put forward enough to show that these documents truly have a predominant legal purpose. Looking at these specifically, we can look at the idea of the draft custodial agreements. That's exhibits 12 and 16. We argued in our brief and we maintain that the assertion of this custodial agreement, or the assertion of the privilege over this custodial agreement is inconsistent, given that Equity Trust has previously produced documents of a draft deposit placement agreement with itself, Huntington Bank and Institutional Deposits Corporation. That was exhibits 37, 38, and 39. Now, I understand that defendants have argued that this doesn't constitute a waiver. However, the law is clear that the assertion of an attorney-client privilege must be consistent. And we're simply showing that this is an inconsistent assertion of that application. And besides the fact that equity trustees argue that they did not waive the privilege and that they only produced these documents because they were ordered to, if they wanted to continue to dispute whether these documents that they produced were in fact attorney-client privilege, they could have done that, but they chose not to. They reached out to us and said that we would like to produce these documents based on our further review. Next document are exhibits 1 to 4, the draft account application for the Sterling Trust acquisition. And that much the same, based on the production of the deposit placement agreements, exhibits 37 to 39, this assertion is inconsistent. So the same is true for the draft letter of intent with Liberty Bank, which is exhibit 6. In addition, they produced other documents related to the Liberty Bank transaction, although they did, as they produced those with redactions. Exhibit 40, the draft insurance deposit agreement with US Bank, very similar and inconsistent production given the tri-party custodial agreement. Now, moving into the response to the SEC inquiries and subpoenas, which are exhibits 34 and 35, there hasn't been any showing that these responses necessarily required legal advice, which is the standard. If the affidavits are simply unclear as to whether these responses could have simply been providing factual information, in which case simply providing factual information, as we've shown through our brief, is not privileged. And just because something ends up going through counsel does not take away from the fact that it's simply the exchange of factual information. Now, on the topic of the Better Business Bureau complaints, which are exhibit 36, Equity Trust has produced customer complaint logs, which are exhibits 22 to 33. Those have been produced with redactions. In addition, the affidavit doesn't show that these necessarily are seeking legal advice. It simply claims that these are seeking legal advice. It's common with responses to Better Business Bureau complaints that really the reason that they're responding to these are for a public relations purpose, not for a legal advice purpose. The purpose is to respond and dispute the claims that an individual made to the Better Business Bureau, not to resolve necessarily a legal dispute, but just to improve the business's standing in the community. And so people don't take a complainant's comments and take them as truth. These are potential factual responses. Now, we have a set of documents that are drafts in-house counsel. There was draft customer account applications, exhibits 52 to 53. We contend again that these are inconsistent based on the fact that exhibits 47 to 51 were produced, which are drafts of fee schedules. And the fee schedule, as we've seen in various versions of the customer account agreement, is included in that agreement and therefore part of the account application. So they're producing part of the document, or a draft of part of the document. Finally, they have withheld draft responses to customer inquiries, exhibits 54 to 57. These are very similar to the Better Business Bureau complaints, where these responses are much more in the vein of PR responses necessarily than resolving a legal dispute. And the failure to show, for instance, anything more besides Mr. Diaz's Mr. Diaz's affidavit on this point is insufficient to carry that burden that they have to show that this is predominantly a legal document, a document seeking legal advice. Now, I'd like to move quickly, as I know my time is close to expiring, to the bank examination privilege document, which is exhibit 66. Now, as noted in Schreiber versus Society for Savings Bank Corp., the bank examination privilege protects only agency opinions and recommendations from disclosure. Purely factual material falls outside the privilege and if relevant, it must be produced. Now, all we know of this document is the heading of it, and the document is entitled Additional Information Requested by Board of Governors of the Federal Reserve System, May 10, 2006. That is a heading that suggests that this is purely factual material, that it's requesting additional information. It doesn't suggest that it's asking for any agency opinion or recommendation, or in fact discussing an agency opinion or recommendation. It's simply a response to a request for information, which falls outside the bank examination privilege. And to defense counsel's point that the trial court or plaintiff's counsel had an obligation to notify the relevant institution, that simply isn't the case, because the court on its own is able to make the determination that this falls outside the privilege. The way this privilege is that if the court were to think that the privilege could potentially be applicable, then at that point it's proper to bring in the regulator. But in this case, the court has simply made a finding that this falls entirely outside the privilege, and therefore there is no need to contact the regulator. And the purpose of that is very simple. To have to contact the regulator in every instance would overburden the regulator, and that's why the trial court can use its discretion to determine whether or not this truly falls or potentially falls within the privilege. I see that my time is about to expire, and for all the reasons that I have provided, as well as the reasons that we've laid out in our briefs, we would ask that this court affirm the trial court's opinion. Thank you, Your Honors.
Thank you, counsel. Counsel, for the appellant, you do have just over a couple seconds over 2 minutes remaining.
Okay, I will be brief. Thank you, Your Honor. Just let me start off. I just have 2 points to make. One is that appellee's counsel admittedly is at a disadvantage, having not been able to review the documents over which we've asserted the privilege. So I would ask the court to examine the documents on their own and not rely on counsel's attempt to characterize those documents as primarily business related or not. As I pointed out, every single document of the 17 that involved the attorney-client privilege involved communications directly to or from the attorneys. So there's no doubt that those are attorney-client privileged. Secondly, with respect to the issue of whether the DIA affidavit is sufficient, in Jacobs 1, in the prior case, we did submit billing records from Ulmer and Byrne. The purpose of that at that time was because some of the communications, many of the communications in that case, were only internal. They were among and between personnel at the company and didn't involve a lawyer on their face, but talked about legal advice that the lawyer, that they had discussed with the lawyer or wanted to discuss with the lawyer. And we produced the Ulmer and Byrne billing records to corroborate the fact that there were these contemporaneous discussions outside of the documents themselves that corroborated our claim of privilege. That's not necessary here. The documents on the attorney-client privilege issue all include the attorneys. And you can judge for yourselves the nature of the legal advice that's involved in every one of those 17 documents. I disagree with counsel's characterization of the bank examination privilege. You can read the Bankers Trust Company to get a better understanding of the scope of that privilege. It clearly applies in this case. It applies to not only communications to and from the regulator and regulators' rulings or decisions, it also applies to drafts of documents that you intend to send to the regulators, which is what's at issue here. And by the way, it's not a purely factual document. That document's about 70 pages. I didn't count the pages. It's between 50 and 70 pages. And it's a draft of a response that's being circulated. Is this how we should respond to the Federal Reserve? So in our view, that falls within the scope. And for the reasons that I've stated, I feel this court should overrule the trial court's decision with respect to all 18 of the documents at issue.
Thank you, counsel. Thank you both for your presentations today and your briefs on the matter. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Have a wonderful day, counsel.
Great. Thank you, Judge.